Welcome, everybody. It is 2 o'clock. We're going to go ahead and get started. And I just wanted to thank you all individually for being here. I know that you are fundraisers and that as fundraisers, you are busy and you are balancing a lot of different tasks. And I'm really thankful that you are here and taking time out of your day to come learn about data security. If you're like me, data security can seem really complicated and really intimidating, but it is so important. And that's why I am really excited to introduce you to our speaker today. I can attest firsthand to how good she is at making data security feel approachable and easy to understand, which is a very special talent that I hope all of you appreciate. Before we get started, I just wanted to introduce myself. I am Abbey Jarvis, and I'm part of the team over at QGive. We at QGive are all about helping nonprofits raise more money. And we focus largely on online fundraising and how to do it well. And that means we look at a lot of data security processes on our end at the QGive office. But while we really emphasize security at QGive, there are plenty of steps you can take on your end to make sure you're keeping your donors' information safe. I know that we have a number of QGive clients on with us. I am so excited to see you. Let me know if you have any questions about how any of this applies to your QGive account. If I can't answer your question, I can at least get you in touch with someone who can. And then if you don't use QGive, everything that you're going to learn here today is applicable to you as well. And then, of course, if you're curious about what QGive does and how we can help, I'm happy to get you in touch with the right people. Just a couple of very small housekeeping items. We are recording this webinar and you are going to get a copy. So don't worry if you have to step away from your desk or if you see something that you really think someone else in your office needs to see. You're going to get a recording of this webinar in your inbox in the next couple of days. And along with that, I'll also send you some other resources that you can use if you want to continue learning about data security. If you have any questions come up while you are watching this presentation, we are very happy to answer those for you. There is a chat box available to you in your little GoToWebinar control panel. Drop your questions in there and we'll have a Q&A section at the end of the presentation. So I am really excited to introduce you to Dr. Heather Mark. She oversees the internal compliance and the security over at Sphere, and they handle things like integrated payments and payment gateways and other services that require really top-notch data security. I got to meet Dr. Mark after QGive and Sphere kind of partnered up and built this really great relationship between our two companies. And she made me feel a lot better about data security. And I am super excited that she's presenting with you. So Dr. Mark, take it away.
Hi, Abby. Thanks so much for that introduction. I hope I can live up to those pretty lofty goals that you've set there. And I want to thank everybody as well for joining us. I know sometimes privacy and security issues can seem very daunting, particularly when it's not your wheelhouse. It's not what you do on a day-to-day basis. But it can be so impactful to the work that you do and so important. So to Abby's point, I feel that it's important to bring privacy and security issues and sort of democratize them to make them approachable and understandable so that at every level of our organization, whether it's your board, whether it's your donors, whether it's your volunteers, whether it's the administrative staff, everybody understands what are our obligations, how do we do it, and how can we sort of integrate these privacy practices into sort of our everyday operations and functions. So I'll skip this slide. Abby's already covered it pretty fully, except to say that I will tell you that as a person who runs compliance and security, it means I spend an awful lot of time reading privacy and security legislation, regulation, studies, and things like that. So I may use some language in here that might not be familiar. And if that's the case, as Abby said, please feel free to enter it into the chat box and we can address it or answer any questions that you might have at the end of the presentation. So we've got a pretty straightforward agenda today. We'll talk about data privacy as it's opposed to security. We'll look at the privacy landscape in the US and sort of how it's changing, both in terms of a regulatory perspective and from a consumer attitude perspective, because as shoppers change, and we've all seen that shift from Boomer to Gen X, which kind of gets skipped over a little bit, which I'm a little bit salty about, to millennials. As those generations change, we see consumer attitudes starting to shift as well. And we'll talk a little bit about how that impacts privacy practice. And then we'll go through 5 proactive steps that you can take, whether you feel as though the privacy laws that are coming down apply to you or not. We can talk about how these steps might put you in a good place should those laws apply to you. And if not, then it'll put you in a good privacy practice sort of place so that your donors and your volunteers and your organization feel better about the transparency of your practices. So with that said, the first place I want to stop is the idea of privacy itself. This is something that really, particularly in the US, sort of gets glossed over. We talk about privacy in the US, and particularly in the compliance space, we talk about it in a way that makes it seem often interchangeable with data security. And it's important to understand the relationship between those two terms. We talk about data security, and that is the protection of confidential information. That's making sure that data that is sensitive remains protected, that it's not subject to unauthorized use or exposure, that it is available for processing or for use when we need it. So for example, if we're processing payment card transactions, we need to make sure that that data is available when we need to process the transaction, and that it is accurate or correct. So somebody can't get in and, for example, change a bank routing number. So that sort of confidentiality, integrity, availability is the cornerstone of what we consider security. Privacy is the appropriate use of data. So if somebody signs up on an information collection form on your website, and they give you the information because they are interested in volunteering or learning more about your organization, then they want you to use that data for the purposes for which it was collected. So you couldn't then go use that data and, for example, sell it to a marketing firm. That would be an inappropriate use of the data. So the way that these two terms are related is that part of privacy is ensuring that the data is secure. So they're intertwined, but they are different concepts. And in the US, we've been a little bit behind the 8 ball when it comes to privacy regulation. You can see in the EU, I'm sure you've all been sort of inundated with news and emails and bulletins about the General Data Protection Regulation, or GDPR as it's more often known, that came out of the EU in the last couple of years. They've always had a very comprehensive view of privacy, a very comprehensive view of individual rights to their own data. Federal law has been very different in the US. In the federal law, we rely heavily on what I like to call latticed privacy regulations. So we have very sector-specific privacy. So in the healthcare, you have the Health Information Portability and Accountability Act, HIPAA, as it's called. You'll have to sign those disclosure forms or those acknowledgement forms when you go to the doctor or the dentist. In the financial services space, you have the Gramm-Leach-Bliley Act. In education, you have the Federal Education Right to Privacy Act. So it's a very latticed approach. It hits certain sectors once. In some sectors, if you're really lucky, you get hit a couple times. So you may be accountable to HIPAA and GLBA. But it's kind of overlapping, and it does leave some gaps, if you will. Well, since the federal law has not been really proactive on privacy, states are starting to take over. They're starting to say, you know what, our consumers need protection, their data needs protection. So how can we do this if the federal government's not going to act? The most well-known law that was recently passed is the California Consumer Privacy Act. It passed very quickly, less than a year, I believe, in session and in debate. It passed at the end of 2018. And there were a number of changes to it just this last year. And in fact, there's still not a final rule that's been promulgated. But CCPA has been referred to as GDPR Light. It's very similar to the European law in a lot of respects, although there are some important differences. But when California sort of passed that law, and they passed it very quickly, other states started taking notice and said, you know what, they're onto something. If the federal government is not going to act to protect consumer privacy, we're going to do it. So since the end of 2018, 11 other states have proposed privacy legislation, and 3 states have passed the bills into laws. So California, Nevada, and Maine have all passed privacy laws now. It sounds very daunting. And it sounds like, oh my gosh, what am I going to do? I'm going to have 50 states now that I have to comply with laws. But actually, and we'll get into this a little bit later, there are several similarities that allow us to sort of apply fair information principles that will help really set you in good stead to address privacy within your organizations broadly enough that you could comply with all of those laws, whether or not they all specifically apply to you or not. One of the most significant differences in the California Consumer Privacy Act in terms of privacy protections is just how broad the class of protected information became. If we look at, for example, GLBA looks at financial information specifically protected in terms of the consumer or customer relationship with a financial institution. So if I'm interested in setting up an account with a financial institution and I provide information to them and do set up an account, then I'm considered a customer. If I don't set up the account, I'm considered a consumer, and there are differences in how that data gets protected as well. CCPA defines personal information much more broadly than any other law that we've ever had. And you can see it on the screen. It defines personal information as information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So it's exceptionally broad, right? We look at names, postal addresses, unique identifiers, social security number, all sort of data that we would consider to be sensitive ourselves. I like to refer to this as the golden rule of privacy, right? I don't want somebody doing to my data what I wouldn't do to my own. And so the data that I might consider personal, I might consider it to be personal information. This law basically considers that to be personal information as well. So we see the landscape of privacy really going through some significant changes, and we see consumer attitudes changing as well. If you look at the path to trust, this is from a PricewaterhouseCoopers survey done in 2017. You can see the really high expectations of consumers when it comes to privacy with the organizations with whom they do business. 85% of consumers will not do business with a company if they have concerns about its security practices. And 88% say the amount of data they share with a company depends on how much they trust it. So this is really interesting in light of other studies that say people are willing to trade data privacy for convenience. But they have to trust that they know what you're going to do with the data. So if you're transparent in how you are dealing with data, hey, if you want to sign up for this newsletter and you want to get free discounts or you want to get benefits or perks, let us send you marketing information. We won't sell it to anybody else, but this is how we're going to use it internally. The more transparent you are with respect to your information privacies or information practices, the more likely consumers are to share their data and to do business with you. But you'll see again, 85% say cybersecurity and privacy risks are among the biggest risks facing society. So these issues of data protection and data privacy are very top of mind for consumers and for donors. We see additionally, they said 4 out of 5 respondents have relatively high levels of concern about the issue of online privacy. 54% of respondents ranked trust in their top 3 requirements for sharing data. I don't think any of these statistics are really going to be surprising to anybody. We talk again about trust and transparency, and those themes are going to come up again and again with respect to the ability to successfully fundraise, the ability to, even from a business perspective, That trust, that relationship essentially with the consumer or the donor is so important. Again, 62% say that data sharing is part of the modern economy. So this is an interesting sort of slice into the view of consumer attitudes. They are very concerned about privacy. They have to have trust with the organizations with whom they're sharing their data, but they're saying the modern economy relies on the sharing of data. And that attitude is even hit home even more with this next slide. If you look at these, there's sort of different slices into the way we can view attitudes about the exchange of personal information. So the exchange of personal information is essential for the smooth running of a modern society. Do you agree or do you disagree? And we can look for the total sample. 33% said, yeah, I strongly agree with that. If we look at the male-female sort of dichotomy, we're getting most folks strongly agreeing with it. You can look also at the generational perspective, the millennials, Gen X, and baby boomers. You can see millennials and Gen X are both very in favor, or at least strongly agree with the view that personal information is essential for the modern running of society. And we see that again as so many of our traditional sort of face-to-face interactions transition to the online world. We see that, and we've been seeing that in retail for 20 years now. We're seeing that in online fundraising and donations and things of that nature now as well. We know these things are going to take place online. So what can we do to make them more transparent and more trustworthy for our donors? And that's exactly what this question goes to. It's really difficult to find a balance to gauge the regulatory impact and the consumer expectation against your data needs. Because in an online world, we have data needs. We're still reliant on that data to process transactions, to build databases, to build marketing lists, to build donation drives, things like that. These are all requirements that we need that data for. So if we look around at the privacy landscape right now, the regulatory privacy landscape, you may be in a watch and wait mode. You might say, okay, California has passed a law. I don't think that I fall into that one yet. They have some specific criteria around do I have over $25 million in revenue? Do I make more than 50% of my revenue from selling data? Am I a California company, or am I doing business in California? So you might look at some of those and go, I don't feel like that really pulls me into scope just yet. But you may find that among those 11 other states that have proposed privacy laws, you might be in scope there. Or you might be saying, you know what, I just want to be proactive. What can I do to start addressing privacy now before that regulation heads my way? And that's a very wise position to take. Even if you feel like, okay, I've got these regulations sort of hanging over my head, I'm not exactly sure what path to take. There are certainly at least 5 steps that you can take proactively that can put you into a good position for addressing data privacy issues. One of the first questions I typically ask when people move into privacy preparation mode is, where's your data? What data do you have? What's your data look like? And sometimes we'll find that a lot of companies don't know what data they have. I think of this in sort of the same way we think about the stuff that collects around our house, right? We hold on to this just in case. We might need this. I have this here because somebody gave it to me for some reason and I might need it in a couple of years, so I'm going to hang on to it. If your data doesn't spark joy, then you might want to start thinking about purging some of it. And the data mapping exercise is a very good way to do that. Mapping the data and information flows throughout your organizations can help you identify privacy risks. And this is something, particularly with smaller companies and companies that aren't, I'll say, highlighted on the radar, companies that kind of think that they're not going to get noticed. This is something that often goes undone and can take people by surprise. So with a data mapping, you look at what data you have, and what's its classification. And when I say classification, I mean, is that regulated data? Is it sensitive data? Is it data that you would prefer as an organization to remain confidential? So data description and classification is sort of the first thing that we map. The purpose of the data. Why are you collecting it? It's very common to find that you're collecting data that you don't need. I think every organization that I've worked with, we've gone through that process where we went, why are we collecting the data? It's not necessary for the purpose. So defining that purpose of the data is very important. Data sharing or transfer. And this to me is a very interesting one, because typically when we think of data sharing and transfer, we might think of something that, okay, this may not be something that the consumer wants it shared or transferred, but it may be required for the purposes of the transaction. So for example, as a payment processor, it's sort of understood that data is going to be transferred onward, for example, to the bank to make sure that you can credit or debit, you've got the appropriate balance, and then come back to you as a response, an authorization or a decline. That data has to be shared, it has to be transferred. There are legitimate purposes for the transfer. You may find as you're going through this process that you're sharing data or you're transferring data to an organization that may not need it. There's no ill intent, there's no maliciousness behind it. It's just the way the process has always been done, and it hasn't been reviewed. So this data mapping classification exercise is very good for looking at where you're sharing data and how you're transferring it onward. It's also extremely important to know if you're transferring data beyond your borders, or you're getting data in from beyond your borders. Many countries now are establishing data localization regimes. So there are requirements around, for example, transferring data from Germany to the US. There are specific rules that need to be in place, specific protections that need to be in place around those data transfers. So really understanding how you're sharing the data, where you're getting it from, who you're transferring it onto is pretty vital. Data retention, and this is again something that particularly in smaller to mid-market organizations can be a little bit of a third rail. How long are we maintaining data? We have a tendency to hold on to data, as I said, just in case I might need it, or that was in reference to something that happened here, and I just want to make sure that we have a record of it. But data retention can be a little bit, again, of a double-edged sword. We want to make sure that we're retaining the things that we need, and we're purging the things that we don't need. So determining how long you've maintained the data, and whether you need that data for a regulatory purpose, for business best practice, and things of that nature are important as well. So establishing a strong records retention regime is critical to data privacy as well. Data protection is probably one of the most obvious things when we're looking at data mapping and data flows. How are we protecting the data? Are we encrypting it? Are we hashing it? Have we got it in a data center with the appropriate physical protections? Do we have it in a database that has the appropriate logical protections? Are we making sure that only people that need access to it have the access to it? So those are the type of things that we suggest for really data mapping, really understanding the data that you have, because you cannot protect things that you don't know that you've got. And it's not uncommon to hear of breaches that occur where people go, gosh, I didn't even know we had that data. So this is an important step, number one, for both data security and data privacy issues. The next one, and I kind of hinted at this one previously, is collection limitation. I call this the data diet. We have to watch what we're taking in. Limit the collection of the data to what your organization needs to fulfill the transaction with the customer. This one's important for a couple of reasons. One, again, from a privacy perspective, the best practice is to use that data only for the original intent of the person who provided it. So if I'm providing you, again, data in order to make a donation or to volunteer with your organization, I would not then expect you to sell that data to a third party or to maybe use it for marketing purposes unless I've explicitly consented. So it's always the best practice to make sure that you're minimizing the data that you're collecting. And again, storing data just in case increases risk and liability. So one way to look at this is every piece of data that you have represents a bit of exposure, a percentage of exposure or liability. The best way to minimize that exposure or liability is to say, okay, I've got this bit of data. It represents this amount of risk. What is the associated amount of benefit that I get from it? As long as the benefit is outweighing the risk to you as an organization, then it may be that you say, okay, we're going to accept that risk and we're going to protect it. But if you don't need that data and it's only representing risk to you, then it might be time to purge that data and change your data collection practices. The next item that we talk about is transparency. And again, we saw this in the consumer attitudes towards data protection, data privacy. We know that our economy runs on data, sort of the lifeblood of our economy at this point. So we know we have to protect it. What are we going to do in order to gain consumer trust? First thing you can do is share your privacy practices clearly and concisely in an easily accessible place. Nobody wants to read through pages and pages of legalese unless you're a strange person like I am who will read the end user license agreement to see what you're doing with my data. I want to know what the privacy says, or the privacy clauses in that agreement say. But most people don't want to do that. They want to find things that are very clearly written, very easily understood, and very clearly explain what you're collecting, why you're collecting it, what you're going to do with it, how you protect it. If you look at the California Consumer Privacy Act, again, that act states that you have to have a disclosure on your website that says what categories of information you collect, why you collect it, what you're going to do with it, how a consumer can access that data. So there are two specific rights that the CCPA provides to consumers that are a little bit of a challenge in the implementation process, but they're very important, and they're very important that consumers know about them. The right to access data. So if I call up to an organization, I can say, I want to know all the pieces of information that you have on me. And they have to provide that to you within a certain amount of time. I believe it's 30 days, and at a reasonable cost. So you have to have a process in place to respond to that. And that process needs to be laid out in that privacy disclosure on your website. The other interesting right that individuals now have under the California Consumer Privacy Act, and it's sparked a lot of debate, and I think it's pretty interesting, is the right to deletion. It's also called the right to be forgotten or the right to erasure. And this is where an individual can call up and say, I want you to remove all information that you have on me. That can be a pretty big ask, depending on the length of a relationship that you've had with a donor or volunteer or a customer. It could be a pretty big ask if you have shared that data with a third party. Perhaps you have a third party that processes your payments or that you use for marketing or event planning and things like that. You have to then contact all of the sub-vendors that you may have to make sure that they're also expunging that person from their systems. The challenge here comes with record-keeping requirements. There are often legal mandates around how we maintain data. If you do anti-money laundering reporting, for example, you have to maintain records for a certain period of time. Or, your organization could be liable for some enforcement actions. So you have to be able to balance that, and you have to be able to address it. So you might have to remove them from your marketing and sales or campaign processes, but maintain them in a data storage environment so that you've got that for record keeping, but that you're not marketing or selling to them or campaigning. So that can be a little bit of a challenge, but that needs to be clearly spelled out in your privacy disclosure. Additionally, if you have sold data within the last 12 months, that needs to be disclosed. You need to have contact information on your website. So if somebody has questions about your privacy policy, they can reach out to somebody within your organization and ask. The key here is giving consumers the right to make an informed decision. So I cannot, for example, tell you that I don't want you to collect my information if I don't know that you're collecting it, or if I don't know what you're doing with it. I need to be able to weigh the pros and cons of sharing my information with you. And in fact, CCPA actually requires that if you have a website that collects information and you sell data, you have to have a button that allows a user to opt out of that sale. And you cannot discriminate then against that user. You can't minimize or change their experience or their service based on that decision not to sell their data. So again, making an informed decision. And the important caveat that I always add to these things is practice what you preach. Don't take a templated website disclosure and put it on your website and think you're going to be okay. And that may sound pretty fundamental. It happens to a lot of companies. If you put a privacy policy on your website, make sure that it matches your practices. The Federal Trade Commission is very good about making sure that companies are practicing what they preach. And so that's potentially what they would consider an unfair, deceptive, and abusive practice in terms of advertising, and they will take enforcement actions against it. So make sure, again, that you disclose your privacy practices clearly, you provide the consumer the opportunity to make an informed decision, but that your practices match your policy. The next sort of building block in a privacy foundation, I would say, is awareness and training. Sometimes we talk about privacy and security, maybe at the management levels or higher, and it doesn't always trickle down well. Or we talk about it, but we don't talk about it in a way that's tactical, that allow other folks within our organization to understand, oh, I have an obligation to this data. I need to make sure that it's not disclosed. Or I see something that's happening that I think is not entirely up to snuff with respect to privacy practice or policy, and I should let somebody know. So training and awareness is very important. Everyone in the organization should know what their responsibility is. So that can be done through new hire training. When you're onboarding somebody new, have them go through a privacy training. It doesn't have to be in depth. It doesn't need to be, a week-long course in privacy or certification, but they should have a basic understanding of what privacy is, what kind of data you're collecting in your organization, and what you're doing with it, and how it's protected. And then on an annual basis, it's recommended that you do a retraining for the entire organization. So you may have practices that have changed. New laws may have come into being. And it's a good idea to make sure, again, that the organization is aware of those changes so that they can continue to operate in a way that is compliant with your policy and with law. So annual retraining. It can vary according to the individual's role. Somebody who is, for example, working in a call center might need a different level of training than somebody who is charged with the administration of the organization as a whole. So it can be tailored, again. Somebody that's working in the IT group that has access to the database might need a more in-depth training on privacy and security issues than your marketing person, just by way of example. So you can certainly tailor that training. And then including your specific policies is really important. It's an important aspect of building a privacy culture within your organization, or data protection culture. I've found that once folks really understand the end goal of privacy and the objective of privacy, they tend to take ownership of it. And it's kind of fun to watch that sort of blossom through an organization where you'll have somebody even, this happened to me recently. I had somebody call me and say, hey, somebody walked away from their desk and didn't lock their computer screen. And I thought, this is fantastic. We're doing the trainings and it's taking hold and people are calling each other and holding one another accountable. And that's really what we're looking for with privacy, where it becomes business as usual. And we do that through training, and not just annual training. We do this through email bulletins. We might do this through posters in the organization. Just sort of a regular sort of drip campaign as to why privacy is important and what our practices are. And related to that, we want to make sure that we're providing a channel for questions and for incident reporting. So if somebody in your organization, or even somebody outside your organization, maybe it's a donor or a volunteer, notices that something's not quite right or they have a question about something, give them access. Let them bring this to somebody's attention so that they can encourage, again, that privacy-focused culture. If you can have conversation about it, that goes a long way to the actual protection of data. It seems like kind of a silly thing to have, if I can encourage conversation about privacy. It may just sound kind of flippant, but it's not. It really allows everybody within the organization, again, to feel like they've got a part of it, and they'll hold one another accountable. This last one is really important. We've heard a lot of these in the news lately around breaches that occur, privacy incidents that occur as a result of a vendor of an organization that had a breach. And that can be just as detrimental as if you yourself had the breach. So one of the recommendations for proactive privacy is really doing your due diligence on partners and vendors. These oftentimes can seem like an implicit endorsement. So if you're an organization and you say, okay, my vendor for payment processing is XYZ company, and that XYZ company has something occur, that can seem like you had made an implicit endorsement of them without necessarily doing due diligence. So partnerships and vendor relationships, very important that we vet them out properly. Make sure that your due diligence includes things like understanding their privacy practices. When you go through the process, ask them, what are your privacy practices? Can we see your privacy policy? They may not always want to put out the whole policy, but they may provide you a table of contents. They may provide you a summary of it. You just want to get a baseline understanding of what their practices are and how committed they are to privacy. If you share your data with a partner or a vendor, again, transparency is very, very important. We need to make sure that we let our consumers know who we're sharing the data with, why we're sharing it, and that the partner or vendor that you're sharing the data with might have different practices than you. That's very important on two levels. One, again, it's transparency for the consumer, allows them to make informed choices, but it's also important for you as well, because you don't want to be held accountable for an action that you had no control over. So making sure that you vet your partners, and if you're going to send, for example, if you're going through a website and you're linking out to a partner, it may just be a little blurb on the website that says, these partners may have different data collection practices, data privacy practices. Make sure that you're familiar with them before you visit the site or before you provide information. So that's really important. Annual review of partnerships and data sharing relationships or data sharing arrangements. We typically suggest an annual review of partnerships in general, just to make sure the business is doing what it's supposed to do. Everybody's delivering on the contract agreements the way they're supposed to. But also, if you've got a data sharing arrangement, it's a good opportunity to say, hey, do we still need to share this data? Are we still sharing data in the way that we contemplated in our contract? As we know, the longer relationships last, particularly with vendors, we can change the contours of what that relationship looks like. So we might have scope creep, we might add new services, we might take away some services, we might be sharing more data, we might be sharing less data. but it's always a good idea to have an understanding of, is that data sharing arrangement still happening? Is it still happening in the way our contract says it's going to happen? And if it's not, do we need to repaper the contract? Do we need to change the way we're sharing the data? Do we need to reel it back into the way it was supposed to be? Sometimes we just get comfortable with partners, and that's a fact of business. But it is a good idea to review that annually, and again, to make sure that your data sharing hasn't sort of expanded past the boundaries of that contract. So if we were to look at sort of the final takeaways for sort of privacy or proactive privacy steps, how we can move forward with putting a privacy program in place when we still don't really know what the regulatory landscape is going to look like. We know that the privacy landscape is becoming increasingly complex. Our economy is more and more dependent on data, and so our organizations are as well. So understanding the data that we have is vitally important. Don't take for granted that you know the data that you have. The data mapping exercise that we kind of walked through, what do you have, where do you get it, where do you send it, what kind of data, how are you protecting the data, how are you retaining the data? That's the kind of exercise that should be done on an annual basis, because your business practices might change. Where you're sending data might change. Maybe you've changed your IT architecture, your network architecture, and that's potentially changed how you need to store data. Maybe you don't need as much data as you did last year because you've changed your processes. So that data mapping and classification exercise is a good annual way to make sure that you're staying on top of the data needs in your environment. The second bullet, don't store data that you don't need. This is vitally important. This is a good piece of advice from a security perspective and a privacy perspective. If you don't need the data, there's no reason to have it. Don't store it. It just exposes you to liability and potential risk. Be transparent in your practices, and that goes for your consumers and your employees, your volunteers, your donors, anybody whose data that you might have. Make sure that you're transparent in your practices. They should feel comfortable knowing that you're doing the right thing with their data. Know your data and your partners. Understand what it is they're collecting, why you're collecting it, why you're sharing it. And this is particularly important if you've got geographically dispersed offices, you've got people working remotely. Sometimes people will develop relationships with vendors and they'll understand, and it'll be perfectly a legitimate relationship, but if the other end of the organization doesn't know about it, you can't take an organizational step to protect that data or to make sure that that vendor relationship makes sense. So that's very, very important. Look for partners and vendors that value privacy as much as you do. When you're vetting vendors and partners, particularly in the fundraising space and nonprofit space, trust and reputation is so vitally important that you want to make sure that you're partnering with organizations that value those ideals, those privacy protections, fair information, transparency. You want to make sure that you're working with folks that value those things as much as you do, because at that point, they're helping to support your business. So you want to make sure that they're going to be there for you. They're going to take the steps that they need to take to make sure they're protecting your donors and your volunteers. And then lastly, find vendors that offer products and services that can help you protect your sensitive data. So look for companies that offer things like encryption, tokenization, secure payment services. Look for vendors that say, hey, we can help you reduce the scope of your data so that you're storing less and you're exposed to less risk. So in essence, even if you may not know specifically what regulations there are out there that can help you, or what regulations might impact your organization right now, there are ways that you can put steps in place that you can already implement practices that can help you be proactive about privacy, address regulation that is in place and that may be coming down the pike. So with that, I'll leave you with a short About Sphere slide. You can read through that. And then if you have any questions, again, you can put them in the chat box, and I will be happy to answer anything that I can.
you. That was such a lot of really great information. And as people drop in their questions, I actually had a couple. So this is something that I know big companies talk about. QGIF talks about security all the time. I know public talks about security all the time. Is this something, like, how aware do nonprofits really need to be? Is this something that they really need to prioritize, or can they kind of fly under the radar for a little while they get things set up? How much should a nonprofit really concern themselves with this concept of data privacy and security?
Well, from my perspective, this should be top of mind for nonprofits, particularly around fundraising. Reputation and trust is such an important concept in that sector specifically. Oftentimes, if an organization suffers a breach, fundraising donations drop off. So I would say, from my perspective, this should be just as important in the nonprofit and charitable sector as it is in any other sphere.
Perfect. I was curious about that. And also, I'm really proud of you for hearing me. Apparently, I sneezed and didn't bring my mic back down near my mouth. So high five to you for hearing me. And also, yeah, I think that is something that is a question that I've heard a lot. Do I really need to worry about this at my nonprofit? And what you said is totally correct. The worry that people have when they're putting their payment information in can be so overwhelming that I think it can put a lot of people off. And I'm really happy to see all these people here that are paying attention to it. But it brings me to another question that I've had. So I know a lot of the nonprofits that we work with at QGIV are small to medium nonprofits. Many people are wearing many hats. Who do you see, or who do you think should own data privacy and security? Who should be paying attention to making sure volunteers are trained and making sure that everybody is compliant and making sure that we're collecting and storing the right data?
That is a great question. And we see this in a variety of areas. I think first thing I want to say is that it is important that you do task one individual with this, because when you've got responsibilities sort of dispersed, then you don't have accountability because everybody thinks somebody else has got it, right? So
Sure.
I do think it's important that you say, okay, this person, you're responsible. And we've seen this in a variety of areas. I've seen it resident in the IT group. I've seen it resident very frequently in the legal group, which kind of makes sense because you've got contractual obligations to privacy. You've got obviously regulatory obligations to privacy. So legal is very often the home of privacy. Not a lot of small organizations, at least in my experience, have a dedicated compliance function. If they did, that's a great place for it. But I would say IT or legal.
Okay.
My preference would be legal because they've got obviously, or not obviously, but occasionally they've got a broader perspective on the ramifications of privacy issues, where IT might be more solely focused on sort of the technology aspects of it.
Absolutely. Is that something that if you have an outside legal team, they can facilitate?
They can. I would suggest that you have somebody internal work on the training materials, because it's often very specific or very particular to an organization in terms of the way that they deal with data. But an outside counsel, an outside consultant can absolutely assist with, okay, hey, what do we need to do? What do we need to have a policy in place? Can you help us with some language around that? Absolutely.
That is very interesting. And I wonder if maybe some small nonprofits could find someone on their board who's willing to do that, or could handle that. It's an interesting thought.
And there are some good resources as well. One that I like a lot is the International Association of Privacy Professionals.
Oh, okay.
And I believe that might be in some additional material that we have. But the International Association of Privacy Professionals has a great FAQ section. They have a great section on very specific privacy laws. And some of the information you might have to log in for. Some of it is gated, but they do have templated information, but they're a really good resource for that. NIST just put out a privacy framework as well. It's a little bit dry because it's NIST, which is the National Institute for Standards of Technology. So it's government reading, but it is a good framework, and it's a good sort of way to measure out maturity of privacy practices.
That is very helpful. And then the other question I wanted to ask, is there any place we should be looking for news on additional legislation as it crops up and as more states start thinking about it?
The easiest thing to do, from my perspective, is Google Alerts. I have Google Alerts set up for all kinds of things.
Okay.
So you can set it up for privacy laws. There is also a website, and I'm not going to remember, probably not going to remember it off the top of my head, but it's a national consortium of state legislatures.
Okay.
And they keep sort of a repository of all of the laws. And they do analysis on specific laws as it relates to the states. So I would do both of those things. I would look at, I believe it's called National Consortium of State Legislatures, and just Google Alerts for privacy law or proposed privacy law or something along those lines.
So I'm writing it down. So it's the National Consortium of State Legislators?
Yes.
Okay. Everyone, I will make sure there's a link to that website and to a couple of the other resources that Dr. Mark mentioned in that follow-up email. As of right now, those are all the questions we've gotten, and you have done a really fantastic job of taking some really high-level concepts that are very technical and making them really applicable to nonprofits, especially small and medium nonprofits that may not know where to start. You've been very helpful, and I really appreciate it. If you guys have any questions about this data privacy and data security, feel free to tweet at us. If we can't get you the right answer, I bet you could probably tweet at Sphere Commerce, or if anything else, we can ask them. You have been so helpful, Dr. Mark. I really appreciate you coming and sharing all of this knowledge with us. Everyone, keep an eye on your inbox for this email that I'm going to be sending you. I'll probably get it out to you tomorrow unless something terrible happens, which we all hope it doesn't. I hope you'll have a wonderful week. Go out there, keep your donors safe, continue to do good in the world. And if QGIV or Sphere can help you, we're here to answer your questions and to help you out. Everyone have a fantastic Tuesday. I hope you learned a lot. We will see you next time.